Hello, it's Philip Taylor speaking from Richmond Green Chambers in London. Today I'm looking at a book which has come to us from Oxford University Press. I'm recording this in the summer of 2017. This book's been published now in a second edition. It's got a long title, Calculation of Compensation and Damages in International Investment Law. So it's quite an important area for anybody involved in certainly international matters. It's been written by Irmgard Marboe. As I say, it's come from OUP. It's part of the Oxford International Arbitration series that they have produced. And Elizabeth and I have given the title for our review the following: Corporate and International Lawyers will welcome this definitive text on compensation and damages in international investment law, now in a new edition. And that's what you've got. Let's have a look at the book first of all. Brown cover, it's a hardback. There we go. Brown cover there. That's the spine. There's nothing on the back at all, but you can see the spine there. It's quite a heavy book. I'm going to go to the back of it first of all. We're talking here of 550 pages. There's the index. You can see how it's structured. The index is by paragraph numbering, and it explains that here. It doesn't, well, it actually should do, but it doesn't. It should normally say in the index it's by paragraph numbering, but it doesn't. But I can tell you it is, in case you're looking to find a particular page number when it's the paragraph number. And there's the bibliography, a detailed one, a lot of information. Starts there, you see, so it runs through for quite a long way. Then you've got some appendices. There's appendices 4 there, a few appendices. Appendices 1, again, they're basically tables. Let's go to the front of the book. You can see that's the International Arbitration series listed there. And you've got a whole series of books which OUP have published. Then you've got this one, that's the front page effectively. And then there's a general editor's preface, which really sets out the purpose of the series of monographs basically. That's dated the 13th of January 2017. And again, that's an important book. The series editor is Lucas Mistelis, he's the general editor. And then of course we've got his preface to the first edition, which is the second edition that we've now got. And then the preface there, which actually sets out why they produced a new edition. There are 7 chapters in total, you can see. And then you've got 4 appendices and a bibliography. That's the detailed contents of the chapters. Then after that you've got the table of cases, quite a lot of case law. You're starting off with the European Court of Human Rights, and then after that we've got table of legislation and instruments which are covered, again all spread out. And then you've got a very useful list of abbreviations, which again I find very helpful in this particular area, because there are some really peculiar abbreviations, no question about that. So it's very useful to know what you're actually dealing with. Then you can see the structure of the book. There's the paragraph numbering there. There's the footnotes. So you can see there's a lot of information that's produced. It starts off by saying, for the long time, the issue of calculation has attracted relatively little attention in legal writing and practice. The main interests of juridical analysis concentrated on the legal foundations of claims, but less on the question of the concrete amount they would be awarded in the end. That, of course, has been the problem, because when you're advising, the client wants to know how much you're going to get. That's the simple bottom line, and there's the middle of it anyway. You can see the way the book's gone. It's a heavy book. So what do we say about this book? We say quite a bit, really, because it's been published in a new second edition now by OUP. It's definitely a major league text on a topic of vital importance to many an international lawyer, and certainly to international arbitrators. That is the award of compensation and damages, largely in dispute between investors, overwhelmingly corporate investors, and nation states. So you're talking of the big time, if I can put it bluntly. Money is, of course, the crux of the matter, whether it comes under the category of damages or compensation or both. And that, right at the beginning of the introduction, that's exactly what the author is saying. And I think that's quite important to at least as a fixture in your mind as to what the book is really about. The ways and means by which the consequently vast sums are calculated will often present formidable jurisprudential and legal problems, the most illustrative of which, and there are a lot of them, are discussed and analysed in the book, with frequent reference to case law and including the most up-to-date developments that have emerged since the first edition came out in 2008. Now, the subject is wide-ranging, as I'm sure you appreciate, so it's useful that the book is a monograph focusing in depth on this subject alone, as it has become in recent years what would now be described as a specialist area. And of course, the whole series, this is the arbitration series, is designed for that purpose, which is what the general editor is saying right at the beginning. It's not surprising then that the book is the first of the OUP's respected Oxford International Arbitration series I just referred to, which is actually, this book has now gone into a second edition, so we're probably going to see more flavour of this in the years to come. And according to the general editor, Matt mentioned earlier, Lucas Mistelis, one of the first books in English, this one, specifically dedicated to this topic. And I'd like to thank him and everybody involved for it, because I think it's a great, valuable addition to what we already know about the subject. International investment, says author Professor Irmgard Marboe, has developed into an important area of international economic law, complemented by a system of dispute settlements and remedies. She comments further that international investment law is less state-centric than international trade law, with private companies being the key actors. And one example of many of significant cases in this area is the matter of the Russian oil company Yukos against the Russian Federation. Also, it's important, I think, to note the very useful diagrammatic tables of cases in the 4 appendices, which we'll look at again at the end. There are over 100 pages in total of them, and that's in the appendices, plus the table of cases and of legislation and instruments that precede the main text. And the amount of research clearly that's gone into the writing of this book is beyond impressive, because this is not the easiest subject in the world to understand, and you are dealing with a lot of money, so I think it's important to get the perspectives right. The bibliography alone takes up more than 20 pages, and to say that the footnoting is extensive is an understatement. What a wealth of references for researchers is presented here then. And this is an academic tour de force in our view, if ever there was one. Let me conclude with a quote. The overall goal of the arbitration process, concludes Marboe, is to ensure that the rule of law is observed. There is little doubt that this timely and authoritative new edition of her highly regarded text will almost certainly contribute to the achievement of that aim, and I'm certain that it will. And as I say, the law is stated as at January 2017. Just have a look at the book again. There's the front of it. And when we look into it a bit more, you see we saw that earlier on. The actual law itself, I'm very pleased to welcome the present 3rd edition, says Miss Stillis. And then what the actual author has done is talking about the rich jurisprudence of international investment tribunals is witness to the importance of awards of compensation and damages in investor-state disputes. Now, it's like most of the stuff I as counsel have, and that is we need guidance. So what do? We get this, which is, and I did mention it earlier, the appendices. And you've got the case number, and you've got what's happened. And you can see from that, it's a very quick, it gives you the economic loss, all the figures. And I think that's a very useful, if you like, ready reckoner, which I think will be of great help to anybody involved in this area. Plus, of course, a tremendous amount of learning that has gone into this book by Professor Marboe. Thank you very much to her anyway, and to OUP for producing what I think is an important book in an area which probably is not understood by that many people. But we are moving into different areas now with Brexit and with the global community. And I think this is a very important area for many people for the future. Big thank you to OUP and everybody involved in this excellent book, including, of course, the Oxford International Arbitration Series. Thank you to all. Bye-bye.